The lawsuit arrived on a Tuesday morning, folded with theatrical precision, and slid into my mailbox like a threat meant to be admired before it was feared. The return address carried the HOA's logo, embossed and smug, the kind of stationery that exists solely to intimidate people who don't read the fine print. Inside was a civil complaint accusing me of unauthorized residency activity, boundary noncompliance, and the boldest claim of all, that I was illegally living outside the HOA while benefiting from its infrastructure. The name at the bottom belonged to the woman everyone in the county knew as HOA Karen, the self-appointed sheriff of other people's lives. She'd finally escalated from letters to litigation. I lived on land that predated the subdivision by decades, a narrow parcel that cut like a seam between manicured lawns and matching mailboxes. When the HOA sprang up, I stayed put. I never joined, never signed, never agreed. My driveway existed before their gate. My utilities ran independently. Still, Karen had made me her project, convinced that proximity equaled submission. She'd fine me for fence height, sent notices about trash cans I didn't own, and once tried to tow my truck for parking after hours on my own gravel. This lawsuit was her masterpiece. I read the complaint twice, slowly, because haste is how people miss leverage. She alleged that my presence reduced property values, violated community standards, and constituted constructive membership through implied consent. That last phrase made me smile. Implied consent is a magic trick used on the unprepared. I wasn't unprepared. I had deeds, plats, easements, and a survey older than her favorite gavel-shaped paperweight. More importantly, I had a calendar invite for a hearing scheduled in 3 minutes. Not a typo. 3 minutes. Karen had filed the suit pro se, writing the confidence of someone who'd watched too many courtroom shows. She requested emergency relief, hoping a judge would rubber stamp an injunction before lunch. The clerk had assigned the matter to the nearest available courtroom.
Mine.
I didn't plan it. I didn't need to. Law has a way of arranging meetings for people who confuse noise with authority. When Karen swept into the courtroom, she carried a binder thick with colored tabs and entitlement. She didn't recognize me at first. To her, I was a problem, not a person. She began her argument breathless and rehearsed, speaking of order, rules, and the sanctity of covenants. She pointed to a map that conveniently cropped my parcel out of existence. She asked for immediate compliance, penalties, and costs. Then she looked at the bench and froze. I introduced myself for the record, calmly, clearly, and without drama. Her binder slipped. The room changed temperature. I asked a few questions, the kind that sound polite while removing load-bearing beams. Had the HOA ever recorded a covenant against my parcel?
No.
Did they possess an easement over my land?
No.
Had I ever accepted services, voted, or paid dues?
No.
Then I reached the issue she'd invited by filing fast and loose. Standing. HOAs derive power from documents. Without them, they're just committees with clipboards. I explained the boundary error in their filings, the improper notice, the overreach in asserting implied consent, and the fatal flaw, their articles of incorporation limited jurisdiction to the platted subdivision, which excluded my land explicitly. By suing me for living outside the HOA, Karen had forced judicial review of authority the HOA did not possess. The remedy followed the rule. I dismissed the suit, vacated the claims, and dissolved the HOA's enforcement authority as applied, effective immediately. 3 minutes, give or take. Karen didn't scream. She couldn't. Silence is what happens when certainty collapses. The hallway outside the courtroom filled with the soft chaos that follows an unexpected ending. Karen stood rigid near the benches, binder clutched to her chest like a flotation device, while the HOA's attorney, late, breathless, and now functionally unemployed, tried to piece together what had just happened. Word travels fast in municipal buildings, and by the time the elevator doors opened, half the floor already knew that an HOA had just lost its teeth. The board convened an emergency meeting that afternoon. Not the polite, scheduled kind with cookies and minutes, but the frantic kind where people speak over each other and discover, in real time, the difference between authority they assumed and authority they actually possessed. Emails flew. Residents demanded explanations. Someone suggested appeal, another suggested rebranding, and Karen suggested doubling fines until people complied. That suggestion landed with a thud. Without enforcement authority, fines are just invoices no one has to pay. The first resident to knock on my door was a man who'd lived there for 8 years and never missed a dues payment. He was pale and polite and holding a stack of receipts. "Does this mean?" he asked, trailing off. I explained what the order did and didn't do. The HOA's corporate existence wasn't erased overnight, but its enforcement authority, its power to compel, penalize, and threaten, had been dissolved as applied. Covenants without jurisdiction are suggestions. Suggestions don't survive contact with the internet. By evening, a neighborhood forum had exploded. Screenshots of the ruling circulated alongside scanned copies of the original plats. People realized the boundary issue wasn't just about me. Several homes on the perimeter had been improperly assessed for years. One family discovered their lot straddled the line entirely. Another found an unrecorded easement that invalidated a decade of fines. Karen tried to moderate the forum, then locked it, then deleted it. That only made the screenshots spread faster. The board issued a statement, carefully worded, legally timid, claiming temporary administrative review. Residents translated that correctly. Retreat. Vendors began calling, asking who would pay invoices. The landscaper paused service. The security company suspended patrols. The pool maintenance firm demanded a new contract signed by someone with authority. No one could answer who that was. Karen attempted a counteroffensive. She filed motions, letters, and complaints to anyone whose title included the word director. Each one failed for the same reason. You can't enforce what you don't own. You can't expand jurisdiction by insisting loudly. And you can't sue your way into power you never had. The more papers she threw, the clearer the picture became. Residents organized not against me but around clarity. They hired an independent attorney who confirmed the ruling and added a blunt footnote. The HOA's incorporation documents contained a sunset clause tied to enforceable jurisdiction. Without it, the corporation could not function as intended. Dissolution wasn't just a consequence, it was baked in. The meeting to vote on dissolution took place in the community center, under fluorescent lights that made honesty unavoidable. Karen spoke first, invoking tradition, order, and fear of what comes next. Then a retired engineer stood up and read the plats aloud. A teacher followed, explaining how implied consent doesn't apply to property law. A nurse asked why she'd paid fines for a mailbox installed before the HOA existed. One by one, the room shifted. The vote wasn't close. Afterward, Karen left early. No speeches. No gavel. Just a binder placed gently in a recycling bin by the door. The neighborhood didn't descend into chaos. Lawns didn't grow wild overnight. What changed was tone. People spoke to each other directly. Disputes were handled like adults handle them, with conversation, compromise, and occasionally a fence built on the correct line. By the end of the week, the HOA's bank account was frozen pending closure. Notices went out confirming dissolution. A quiet settled over the streets, not the silence of control, but the calm of resolved confusion. I walked my driveway at dusk, the same gravel underfoot, the same trees overhead. Nothing about my land had changed. What changed was everyone else's understanding of it. The lesson traveled farther than our neighborhood. Nearby associations requested audits. County clerks fielded calls. Somewhere, another Karen read the story and decided not to file. Once the paperwork settled, something more interesting happened. Reality replaced rumor. For years, the HOA had operated on momentum, assumptions stacked on assumptions, enforced by confidence and a letterhead. With that gone, people started asking quieter, smarter questions. Who actually owned what? Which rules were real, and which were just repeated often enough to feel true? The answers rewired the neighborhood. The county recorder's office became a field trip destination. Residents who had never looked up their own deeds were suddenly fluent in plats, easements, and recording dates. A retired librarian organized a shared drive with scanned documents. A software developer mapped the subdivision against official surveys and found discrepancies that explained years of neighbor disputes. The narrative shifted from "we have to" "do we actually?" Karen tried to regain footing by reframing. She called it a pause, then a transition, then a community reset. She emailed former board members with a proposal to form a voluntary association, no enforcement, just guidelines. Attendance was thin. Voluntary rules are only appealing when people trust the rulemakers. Trust had left the building. What surprised everyone was how little fell apart. Trash pickup continued. Neighbors coordinated snow removal with a group text. The pool reopened under a co-op schedule with posted hours and shared responsibility. Without fines looming, people showed up. The absence of punishment revealed something HOAs rarely credit. Most people want their neighborhood to function. There were edge cases, of course. A dispute over a fence line flared, then cooled after a joint survey split the difference. Parking complaints popped up, then resolved with painted curbs agreed upon by the block. Without Karen's megaphone, problems stayed proportional. The sky didn't fall. It stopped being threatened. Legally, the ripple effects widened. The independent attorney filed notices clarifying jurisdiction for every bordering parcel. The county issued guidance reminding associations that proximity does not equal power. A regional HOA management company quietly updated its intake checklist. They'd learned the expensive way that everyone knows isn't a defense. I received letters, some grateful, some curious, a few defensive. One accused me of winning on a technicality. I replied politely, "Property law is made of technicalities. Boundaries, records, signatures. Those aren't loopholes. They're the point." Another asked if I'd planned it. I hadn't. The law doesn't need choreography. It needs patience. Karen reappeared once, months later, at the grocery store. She avoided eye contact, then surprised me by nodding. Not an apology. Not a challenge. A nod that said the story was over. She'd moved, I heard, to a place with stricter covenants and a bigger board. Some people don't change. They relocate. The neighborhood kept evolving. A monthly potluck replaced the board meeting. A shared tool shed appeared by consensus. A bulletin board went up near the mailbox cluster. Real cork, real pushpins, no approval required. Kids biked without signs telling them where not to ride. Adults talked before emailing. The most telling moment came when a developer proposed a new build on a nearby lot. In the old days, the HOA would have postured and postmarked. Instead, residents requested plans, met the builder, negotiated setbacks, and recorded a limited easement everyone could read. No drama, just documents and dialogue. People often ask what dissolved the HOA. The short answer is overreach. The longer answer is certainty, without authority. Karen believed belief itself conferred power. The law disagrees. Power flows from consent and record, not volume. On a quiet evening, I stood at the edge of my land where the survey marker sits flush with the soil. It's unremarkable, just metal and numbers, but it represents something rare: clarity. Lines matter. When you respect them, communities work. When you ignore them, someone eventually reads them aloud. With the HOA dissolved, the aftershocks became administrative rather than emotional. That's where most power stories quietly end, not with shouting, but with forms. The county required final filings, bank closures, and vendor releases. Each step forced the truth into places it had never been required to go before. When authority evaporates, accountability finally has room to sit down. The former treasurer discovered that several years of dues had been misallocated to enforcement contingencies, a category that now meant nothing. Refunds were discussed, then disputed, then calculated. Not everyone wanted their money back. Some wanted explanations. A few wanted apologies. What they got were spreadsheets. It turns out numbers are harder to argue with than people. Insurance was next. The HOA's liability policy hinged on enforcement activity and common area control. Without either, coverage lapsed. That revelation mattered because it explained why the board had always been aggressive. Enforcement justified insurance. Insurance justified enforcement. A loop. Break it, and the machine stops humming. The management company sent a final letter expressing regret for any inconvenience. It included a line offering services to newly formed associations. No one replied. The lesson had landed. The neighborhood wasn't anti-structure, it was anti-fiction. Structures built on consent last longer than those built on fear. A few residents worried about resale value. Realtors answered with comps from nearby areas without HOAs, stable, sometimes better. Buyers asked different questions now. Internet speed, drainage, tree cover. Not mailbox paint codes. The market adapted faster than the myths. Karen attempted one last procedural move, a petition to reinstate under revised articles. It failed for a reason she'd never quite accepted. Jurisdiction can't be voted into existence. You need deeds. She didn't have them. The clerk's denial was brief, polite, and final. Time did what time always does when noise subsides. It normalized. New routines replaced old warnings. The pool schedule lived on a laminated sign. The shared drive hosted minutes from voluntary meetings, notes, not mandates. Disputes went to mediation when needed, which was rare. Without a hammer, every problem stopped looking like a nail. I was asked, more than once, why I didn't push further, sanctions, penalties, a public rebuke. The answer is simple. The goal wasn't punishment. It was accuracy. Once the record reflected reality, the rest took care of itself. Law isn't about winning arguments. It's about aligning paper with the world it describes. There was a quiet dignity in watching people reclaim agency, without theatrics. Authority that announces itself is usually compensating. Authority that works doesn't need an announcement. It shows up as fewer letters, shorter meetings, and longer dinners. One afternoon, a kid chalked a hopscotch grid across the old no loitering zone near the mailbox cluster. No one complained. Someone added numbers. Someone else drew stars. That's not a metaphor. It's just what happens when space stops being policed by default. The broader impact surfaced later, in conversations with clerks and attorneys from neighboring towns. Associations reviewed their boundaries. Boards requested audits. A few disbanded quietly. Not because they were evil, but because they were mistaken. Correction is not collapse. It's maintenance. If there's a takeaway, it's this. Living outside someone's rules isn't rebellion if you never agreed to them.
Consent matters.
Records matter. And when someone sues to force reality into their imagination, reality tends to respond, promptly, and with exhibits. The story didn't end with a bang or a headline. It ended the way most durable things do, by settling into place. Months passed. The neighborhood found its rhythm. The absence of an HOA didn't create disorder. It revealed how much order had been coming from people all along. Lawns were still mowed. Mail still arrived. The sky didn't collapse without a committee to warn it not to. Occasionally, someone would ask if I missed the structure. I'd smile and say structure isn't the same as control. Real structure is visible in deeds, surveys, and agreements that say what they mean and mean what they say. Control relies on ambiguity. Once the ambiguity was gone, so was the conflict. The most telling moment came when a new family moved into one of the perimeter homes. They asked the right questions about utilities, access, and boundaries. No one handed them a binder. They were shown a map. They were told the truth. They nodded, relieved. Transparency is a better welcome packet than rules. Karen's name faded from conversation. Not because she was forgiven or condemned, but because she was no longer relevant. Power that depends on constant attention withers when ignored. The neighborhood didn't need a villain anymore. It had clarity. From a legal standpoint, the case became a quiet citation, used in trainings, referenced in memos, never sensationalized. It served its purpose. When someone tried to argue implied consent months later in a different dispute, a clerk shook their head and said, "Not like that." That's how precedent actually works, not with applause, but with fewer mistakes. I kept my routines. Morning coffee on the porch. Evening walks down the same gravel drive. The land didn't care about lawsuits. It had been there before the subdivision and would be there after every argument found a filing number. Ownership isn't loud. It's patient. What lingers isn't satisfaction, but a kind of calm respect for limits. Lines on a map are promises. When you honor them, neighbors become neighbors again. When you ignore them, you invite correction. Karen invited it with a lawsuit. The law answered with a ruler. If there's a final lesson, it's this: living outside an HOA isn't a loophole, it's a fact. And facts, when properly recorded, don't need permission to exist. They just need someone willing to read them aloud when noise gets mistaken for power. The driveway is still mine. The land is still mine. The quiet is shared. And the story, like all good ones, ends not with dominance, but with boundaries respected.